Much obliged. Your Honor, the first issue framed by this honorable court, the civil court has got the jurisdiction to entertain the suit. So, Your Lordship, my first submission before this honorable court is no, the civil court has got no jurisdiction to entertain this suit because, Your Lordship, I want to draw the attention of this honorable court to page number 7 of the Moot proposition. Your Honor, page number 7 of the Moot problem. Your Lordship, if we look at the clause number 8, para number 1 of the Moot proposition, it categorically says that, Your Lordship, it categorically says that in the event of a dispute arise out of or in connection with this contract, the parties agrees to attempt resolution through negotiation. Your Lordship, point to be noted here. My Lord, here the plaintiff,
Page number?
Your Lordship, page number 7 of the Moot proposition, clause number 8, para number 1, which categorically says that, Your Lordship, in the event of a dispute arising out of or in connection with this contract, the parties agrees to attempt resolution through negotiation. Here, point to be noted, Your Honor, the plaintiff Ali Raza has completely overlooked, and I can say that plaintiff Ali Raza has violated the contractual obligation on which he has willingly signed this contract, that an event arising, that a dispute arises, we will consult this, we will resolve this through negotiation. But instead of negotiation, Your Lordship, he directly approached the civil court, which is not the proper forum to entertain this suit, because the plaintiff Ali Raza should solve this matter through negotiation. Furthermore, Your Lordship, if we look at the para number 2 of the clause 8, that categorically says that if a resolution is not achieved within 30 days, either party may refer the dispute to arbitration under the Arbitration Act 1940. I want to draw the attention of the Honorable Court here. Point to be noted, my Lord, here they have completely violated the second option. After the negotiation, he should do that, he should try the arbitration. But again, for the second time, he has completely violated his contractual obligation and directly filed the suit in the Islamabad Civil Court. That is why, my Lordship, it is my humble submission before this respectable court that this honorable court, that the plaintiff should resolve this matter through negotiation and the arbitration. That is why the civil court has got no jurisdiction to entertain this suit. Your Lordship, clause number 5 of the contract categorically says that in the case of regulatory delays exceeding 12 months, the clause 5 of the contract, while the plaintiff is claiming the refund with interest, Your Lord, my Lordship, point to be noted here, the plaintiff is claiming the refund of payment with interest, which shows that they are completely violating the terms and conditions of the contract. Your Lordship, this contract, my last submission regarding this issue before this respectable court is that the contract is still ongoing, and we are not denying the position of the plaintiff. First, the plaintiff should fulfill their contractual obligation, and your Lord.
Then it also has regard to the provision of Section 12 of the Pakistan Environment Protection Act 1997. It says that the compliance with this requirement is mandatory before initiating any development, construction, or project of the same. What do you say? Have you violated Section 12?
No, Your Lordship. Your Lordship, when the defendant was signing the contract with the National Real Estate Corporation, that was categorically mentioned in that contract that the time period for the plot will be 24 months. We are still here. We will give the plot within 24 months to the.
It means that counsel, you are ready to get the required certificate from the concerned department.
Of course, Your Lordship, we are trying a lot, and we are trying a lot, and we have still we have 24 months, which is a lot of time, and we will complete the plot of the buyer and Ali Raza and other.
But as per Section 12, it was mandatory before initiating any constructions. compliance with this requirement is mandatory before initiating any development construction. You started your development construction before complying this mandatory provision.
Answer to your question, Your Lordship. On January 1st, 2023, the Environmental Protection Agency has issued provisional environmental clearances to the National Real Estate Corporation, and after that, we continue our work again, and the National Real Estate Corporation is trying to complete the plot within 24 months. As we have signed the contract, we are still with the contract, and we have not reached the contract. 24 months are available. The reasonable time frame is 24 months, and we will complete the plot within 24 months. Your Lordship, they have completely, first they had agreed with us for the negotiation if a dispute arises, and then they violated again, and the second, the negotiation to arbitration, but he didn't consult with the National Real Estate Corporation and directly filed the suit with the Islamabad Civil Court in the Islamabad Civil Court.
Okay, Honourable Counsel, you have said there is a arbitration clause in the agreement, but there is no mentioning that how this will be arbitrated will be appointed. There is no black and white in the procedure of the appointment of arbitration agreement. In which case, what will be used? When there is no procedure provided in the agreement.
No, Your Lordship, there is mentioned that the Islamabad Civil Court will appoint the arbitrators to resolve the issue.
Which clause you will say?
May I take a moment before responding? May I take a moment before responding?
Okay, please.
With due permission of this honorable court, may I address this?
Please. No. We agree that there is an arbitration clause in the agreement, but this said that any party may, you may approach to the arbitrator instead of plaintiff. You may also approach to the arbitrator. Yeah, you may file petition under Section 20 of the Arbitration Act before the Court of Civil. Okay, in this case, tell them the proceeding of the civil court may be stayed, and then proceed with the arbitration case.
In Myanmar once, you said that there was a condition in the contract that the mutual dispute that could be resolved through negotiation.
Yes, sir.
That was a condition.
Yes, sir.
So, tell me that if a mutual agreement can bar the jurisdiction of the civil court.
Your Lordship, according to the contract 1872, the plaintiff was bound to for the negotiation.
No, he was bound. But my question is that mutual contract, mutual agreement conditions set in the contract can bar the jurisdiction of the civil court. For example,
Whether the party can settle the conferred jurisdiction upon a court with their mutual consent.
Your Lordship, that is mentioned in the contract. So then why the civil court has got?
You must refer to the arbitration
Yes.
act. You must refer to
Answer
the
to you.
arbitration act. It is categorically mentioned that when there is an arbitration clause, the party may file a petition under Section 20 of the Arbitration Act before the Court of Senior Civil Judge to the fact that the matter be referred to the arbitrator.
Yes.
Okay. May I continue?
You people also have an option. Either party may into your contract arbitration clause से उसमें either party can refer the matter to
जी सर.
आपके लिए open है.
सर आंसर टू योर क्वेश्चन सर, क्योंकि हमारे पास 24 महीने थे, उस 24 महीने में हम उसको प्लॉट डिलीवर करने वाले थे. कॉज ऑफ एक्शन हमें एराइज नहीं हुआ सर. कॉज ऑफ एक्शन उनको एराइज हम तो अपने जो ऑब्लिगेशंस थे वो फुलफिल कर रहे थे, और इस हवाले से वो डायरेक्टली विदाउट इन्फॉर्मिंग अस, योर ऑनर, विदाउट इन्फॉर्मिंग अस दे फाइल्ड अ सूट इन इस्लामाबाद सिविल कोर्ट.
आप जानिए ना उनके आपको तो काउंटर ब्लास्ट और आपको arbitration भी ये either party may के लिए तो
आप चले जाए
आपके लिए ओपन है।
और हम इस पे स्टे की एप्लीकेशन फाइल कर दें कि जी हम ऑलरेडी एडवोकेशन के पास फाइल की हुई है, आप एक एप्लीकेशन फॉर रिजेक्शन ऑफ रेंट के लिए फाइल कर दें। हैव यू फाइल दिस एप्लीकेशन व्हेन यू आर इन इनिशियल स्टेट? इज द फाइनल आर्गुमेंट्स। ओके, प्लीज कंटिन्यू। जी प्लीज
With due permission of this honorable court, may I proceed for a second? Your Lordship, the issue number second raised by this honorable court is whether the defendant NREC committed a breach of contract by failing to obtain the required environmental clearances, thereby acting negligently. Your Lordship, my first submission before this honorable court is the defendant NREC regulatory clearances. Your Lordship, my first submission before this honorable court is that the defendant NREC didn't fail in complying with the required environmental clearances. Your Lordship, the NREC submitted their re-compliance report to the Environmental Protection Agency on 20 February 2024, while the CDA issued a notice to the NREC for halting construction on 1st February 2024. Your Lordship, there is a considerable gap of 11 months and 10 days. Despite passing of almost 1 year, the EPA did not issue environmental clearance, which was a bureaucratic delay and beyond the control of NREC. Your Lordship, the Council would like to draw the attention of this honorable court to clause 3, sub-clause 3 of the contract agreement, which clearly state that all requisites approval from governmental authorities for the sale and development of the project have been applied for, but certain clearances, including environmental clearances, are still pending as of the contract signing date. Your Lordship, it is categorically and explicitly mentioned in clause 3, sub-clause 3 of the contract agreement that all requisites approval are still pending as of the contract signing date. Your Lordship, the contract was signed between the plaintiff and Ali Raza on 1st March 2023. Your Lordship, the provisional environmental clearance to the NREC was granted on 1st January 2023. Your Lordship, the NREC acted diligently and with reasonable care by granting of the provisional environmental clearance under Section Environmental Protection Act 1997. Your Lordship, as the contract was signed between plaintiff Ali Raza and the defendant on 1st March 2023. Your Lordship, the required regulatory approvals under Section 12 of Pakistan Environmental Protection Act 1997 was fulfilled by the defendant NREC. Your Lordship, the facts was misconstrued by the respected learned counsel for the plaintiff. Your Lordship, Class 4, subclass 1 of the